Now let's take into account certain other relevant considerations. What if the class of consumers of the plaintiff and the defendant are different? Quite often, defendants try to raise a defense that the pricing of their goods is very different from the plaintiff's goods. Let's say, for instance, in case of a car, I might say that as a defendant I might say that the cost of my car is only 1 lakh rupees while the cost of the plaintiff's car is 10 lakh rupees, and because of this there is no likelihood of confusion. While some courts do give weightage to this fact, slowly and steadily this factor is becoming less and less relevant. Courts are saying that since cars may be sold online, people may be still diverted to the less expensive car when they are looking for the more expensive car. This confusion is sufficient to cause trademark infringement. Let me give you an example. If two car manufacturers are using very similar trademarks, let's say Tata and Tatva, while searching for Tata, even if I come across the Tatva car, I might go and visit the Tatva website. I may not buy the Tatva car which is only worth 1 lakh rupees, but because I have gone and visited the Tatva website, I might look at its other cars which might lead to trademark infringement. This is called initial interest confusion, because even though at the time when the consumer will buy the Tatva car, he or she will know that it is not a Tata car, but because the consumer has visited the Tatva website, because of its confusion with the Tata website, it will be considered trademark infringement. Also, another important consideration is that in a trademark infringement case, actual confusion need not be proven. That is, a plaintiff need not show that actually a consumer was confused because of the defendant's use of the trademark. All that the plaintiff needs to show is that there is a likelihood of confusion, and that too from an eyes of an unwary purchaser with average intelligence and imperfect recollection. Now, it's also important for you to know the kinds of uses that can be considered as infringement. 1. The use of a trademark as a trade name or a part of a trade name. Therefore, if a defendant goes to the registrar of companies and registers a corporate name which is similar to the plaintiff's trademark, then the plaintiff can file a suit for infringement of the trademark before a court. Second, the affixation of a trademark to the goods or packaging. Therefore, if the defendant uses an identical or similar trademark on its goods or packaging, then it is liable for trademark infringement. If someone puts the goods on sale on the market, that is also considered trademark infringement. Fourthly, the import or export of goods which misuse another person's trademark is considered trademark infringement. Lastly, use of the trademark on business papers or in advertisement is also considered trademark infringement. Therefore, you might notice that the Trademarks Act seeks to impose liability on many different actors. Even though all of these acts may be performed by one person, it is important to impose liability with respect to each of these acts so as to avoid a situation where a person goes scot-free for trademark infringement because it is not performing one of these acts. Now, let's move on to the second part of the rights which are granted in a trademark, that is the common law rights. As I mentioned earlier, there are two types, the statutory rights and the common law rights. When the common law rights are infringed, we move to the law of passing off. Passing off has three elements. One, that the plaintiff must prove that its mark has reputation. Secondly, the plaintiff must prove that the defendant has misrepresented. When I say misrepresented, I mean that the plaintiff must prove that the use of the mark by the defendant is likely to lead to consumer confusion such that people are likely to believe that the defendant's goods originate from the plaintiff. Lastly, the plaintiff must prove that it has suffered some injury or loss. Now let's try and understand what is the difference between passing off and infringement. Passing off does not use the added matter doctrine that I mentioned earlier. In passing off, a defendant can take a defense that because of the surrounding circumstances, because of the prefix, suffix or other trade dress differences between the plaintiff and the defendant's use of a mark, the consumers are not likely to get confused by the defendant's use of an identical or a similar trademark. Secondly, in respect of common law rights, it is important for the plaintiff to prove reputation. Therefore, if a person has to claim common law rights in a trademark, he or she must show a long continuous user of the trademark such that it has acquired a reputation in the mark, such that people associate that particular mark with that particular person, and only if such reputation and goodwill in the mark is proved can he or she claim common law rights in the trademark. In contrast, with respect to trademark infringement, it is not at all necessary for the plaintiff to prove reputation in the mark, so long as the plaintiff has acquired a registration before the trademark's registry. He or she can claim trademark infringement irrespective of the use that the plaintiff has made with respect to that trademark. Let me summarize the concepts that we have studied today. We first studied the distinction between the statutory rights and the common law rights in a trademark. The statutory rights are conferred by the Trademarks Act for a registered trademark, and the common law rights arise from common law and are with respect to an unregistered trademark. The Trademark Act specifically provides that a suit for infringement cannot be filed with respect to an unregistered trademark. However, at the same time, it recognizes that the relief of passing off is still available to any person who has common law rights in a trademark. There are two rights which are available to a registered proprietor of a trademark. That is the right to use and the right to obtain relief. Then we also studied the concept of an unwary consumer with average intelligence and imperfect recollection. This is the person from whose eyes likelihood of confusion needs to be judged. There is some variation of this principle when the goods in consideration are more expensive. In such cases, the consumer is considered to be a discerning one. Then we studied as to how consumers interact with trademarks. We also understood how the distinctive part of the mark is the most relevant in forming a mental association, and thus the Trademarks Act seeks to protect this distinctive part of the trademark and the decline in the accuracy of a consumer's memory-based judgment. We next studied the rules for determining the similarity of trademarks. These rules are very important and have evolved by case law over several years. The side-by-side comparison of trademarks is inappropriate. The visual and phonetic similarities of the trademark must be seen. The test is of similarity of ideas has already also been adopted. The rule of anti-dissection has also been adopted in India. An added matter is not relevant with respect to trademark infringement. We also looked at the concepts of different in class of consumer owing to difference in prices and its decreasing relevance, and we studied that actual confusion need not be proven in a trademark infringement case. We also studied the law of passing off, its three elements, and the difference between trademark infringement and passing off. Thank you.